Welcome to the Three Questions webcast series. I'm Wayne Baxter, Senior Executive Manager with One Capital Management. On this edition of the webcast, we're going to address the three questions business owners should ask before terminating an employee. Thank you for taking time to check us out. And if you enjoy this episode of the Three Questions webcast series, please consider liking this video and subscribing to our YouTube channel. Now, my clients are often referred to as cross-border clients. Now, why is that? Well, it's because they're either U.S. or Canadian residents who invest in U.S. and or Canadian dollar denominated securities like stocks, bonds, and ETFs. At One Capital Management, we develop and implement strategies that strive for our clients to grow, protect, and ultimately distribute their wealth, and we do that by offering investment wealth management services. Now, our process for advising our clients includes an in-depth discovery and diagnostic analysis of their wealth management goals and objectives. And for some of our clients, their focus may be on managing a business in order to create wealth. In addition to thinking about their wealth management goals, they're going to be focused on developing a strategy for building their business. Now, the goal of the webcast here is to educate and inform you about some of the financial issues that you may encounter, and in doing so, introduce you to experts that may be able to assist you. On this edition of the webcast, we're going to talk to an employment attorney about how business owners can avoid costly, unnecessary pitfalls when they need to terminate an employee. Joining me is Katherine Hren. Katherine is an employment attorney and a partner with Encino, California-based Ballard Rosenberg Golper Savitt, LLP. She regularly provides advice and counsel to employers in all matters which bear upon the employment relationship. She represents employers of all sizes throughout the United States, from mom and pops to Fortune 500 companies. Katherine, finally got you on the webcast. Thank you for making time to join me today.
Thank you for having me, Wayne. I'm really excited to be here.
Yeah. Well, so here's the thing, Katherine, I was mentioning before we started here, I always think of Katherine as being a real force. I attend a lot of in my community world. I'm a member of Provises, and Katherine does probably every 6 months, maybe even every quarter, she'll give us an update. And when she does her what's going on in the employment world update, all eyes and ears are paying attention to her. She's a great speaker, does done a lot of talks, and a part of her firm's preventative philosophy, Katherine designs and presents customized internal management training programs on a broad range of employment law related issues. And there are plenty of employment issues for employees on your plates these days. There are hour and wage loan issues, workplace safety and health, discrimination and harassment, family medical leave, immigration compliance, and employment privacy rights. So at this point in time, from where you sit, Katherine, what employment law related issues are keeping business owners awake at night? We'll say, generally speaking, across the country. What's keeping them awake, making them pull out their hair, chewing on their fingernails?
One simple word: employees. Being a business owner inevitably, in most cases, means you have to have employees. And I have a saying that says you end up spending about 90% of your time dealing with 10% of the workforce. Most employees don't have issues doing their job. They have issues interacting with other employees in the workplace. And being a business owner, you're in a difficult spot of trying to manage all those relationships and manage people's expectations, all in the while expecting to be an expert and knowing every single employment and labor law. We have employment laws that are legislated at the federal level, state level, and in most recent years, we're seeing so many new legislation ordinances coming out of cities, counties. So you can't just say, what's the minimum wage, Katherine? Because I have to know, where are you? What state are you in? What city are you in? How many employees do you have? The simple employment questions that I used to get asked are so complicated today. So really, business owners are spending an enormous amount of time on their employees these days and the issues that are faced with.
Well, on that note, according to the U.S. Bureau of Labor Statistics, get this, there are approximately 151 million employees across the U.S. Believe it or not, 151 million employees. So there's no question there's plenty of work for employment attorneys like yourself. It's not a dying business, that's for sure.
Not at all. They keep us very busy.
So let's get to our three questions business owners should ask before terminating an employee, God forbid that they have to. Right. So question number one: does the file match the story? Katherine, take it away.
That is the first thing I ask a client when they call. So in my practice, I represent only employers, business owners, management side. So big piece of my practice is answering the day-to-day advice questions. And almost once a day, if not more, I get the call, we want to terminate this employee. And the first question I ask is why? Tell me why. Give me your story as to why you want to terminate this employee. Oftentimes it's performance-based or attendance issues, or they're not the right fit. They don't get along well with others. They're not doing their job duties. It's a whole host of different reasons why someone would want to terminate their employee, obviously. So the first thing I say to them is I said, what does the file say? Half the time I get, well, what file are you talking about? Because first of all, we're expected to maintain a personnel file.
Yikes.
All right.
That's not the answer you want to
Not
hear.
the answer you want, but you're expected to maintain a personnel file. So what does it say? Most employees really operate under the impression that no news is good news. So if employees aren't getting constructive criticism, they assume they're doing their job.
Mhm.
The other thing that becomes a problem is, okay, so let's say you go and you take the time and you say, okay, I'm going to do a formal review. I'm going to put something in writing. And you've got a rating system that's, let's say, 1 to 5, with 3 being satisfactory. And so I look at this review and it says that the person's performing satisfactorily in all the categories. I'm going to say to you, that doesn't tell the employee that they're not doing their job. You might consider them mediocre, not doing their job, but the plaintiff's attorneys, the people that are representing employees and suing employers, will put that back in your face and say, you rated them as satisfactory, and now you're telling me they're a terrible employee. It must not be true. It must be some other reason, like they filed a harassment complaint, they got injured, they needed a religious accommodation, any number of things that we would call protected activities. So does the file match the story that you're telling me? If you told me that they're having attendance issues, are there write-ups for their attendance issues? If you're telling me employees have complained about them, managers have complained, where are those complaints? Are they in writing? Were they verbal? It's really important to have things in writing when it comes to terminating an employee, because if you don't, you're vulnerable to the other side simply saying that never happened, you can't prove it. And then you get into a competition of credibility and he said, she said. And that's not going to be a great way to defend your case. It's not the best way to defend yourself in an action for wrongful termination or discrimination. So we've got to have a file that tells the story. If there's a lot of good positive things in there, then your argument that you terminated them for bad things they did is not going to hold up. And if there's nothing in there, the same is true, that we're just going to assume that no news is good news. So you really want to make sure you are taking that opportunity to sit down with an employee, giving them the constructive feedback. It doesn't always have to be a formalized process like a review. It can be as easy as sitting with them and then sending them an email and saying, in follow up to our conversation today, here's the points that we discussed. And now you've got a record of when it happened. You got an email with a time and date stamp. And if you take any handwritten notes, I always tell clients, please insert in there the date and the year that it's written, because often when we get these claims and we're defending them,
April 25th.
Yeah, you got to put it in there. Got to have the date in there.
Good. Okay, so I mentioned in sort of our part of the intro that you do a lot of talks. I know you do a lot of. So when you're working with an existing employer client of yours, how much of your sort of preventative talking is teaching, educating, and instructing them how to basically put that infrastructure in place? Is that a lot of what you're doing, is trying to encourage, nudge, persuade, cajole them into getting these practices as a part of a regular business operation or business systemization?
Absolutely. And I have a lot of long-term clients that I've worked with for a couple decades where I say they're very well trained. When they call me or they schedule a call, they will send me everything I need to look at before the call. They'll send me the person's file. They'll have it teed up. They'll tell me the information that they know I'm going to ask about, so that they're putting together these processes to put themselves in the best place possible to conduct terminations or layoffs and to be able to defend them in the event that they do get a lawsuit.
So you're usually working with an HR related position, employer or employee within the firm.
Yes, in many cases, I'm working with HR personnel. In smaller companies, it's usually one of the executives because they don't have HR departments. They wear many, many hats. In bigger companies, yes, it'll be corporate counsel or HR individuals.
And I suspect it's in those companies where there is the multiple hats are being worn is where there's probably more likely to be the sort of the lack of infrastructure.
Yeah, we do. We see a lot of that. There's always a lack of infrastructure. There's not formal protocols or processes in place. Everything's kind of done it's reactionary. There's not a lot of preventative things going on. There's not a lot of avenues for employees to get information, to make complaints. Oftentimes in those type of companies too, you have managers that have just been promoted through the ranks without any real management training. So, and they are the ones typically that get you in trouble because in many states, there's a strict liability standard. If a manager or supervisor engages in behavior, then the company is automatically liable. So it's really important also to keep in mind that when you're promoting managers and or hiring managers, managers have two main focuses of their job. One, they have to do their job. And two,
Right.
they have to manage people.
Right.
Two completely different skill sets.
Yeah.
And you want to make sure you're setting them up for success in both areas and also giving them the tools to protect the company from things that they may do, or and oftentimes things that they don't do because they don't know they're required to do them.
Right. Ignorance is a bliss and the mother of adventure, as they
Until you get sued.
Yes, exactly. Well, that's the adventure part, right?
Right.
Okay, so great answer for the first one again about does the file fit the story, or does the story fit the file? So for question number 2, again, these are 3 questions that a business owner should ask before terminating an employee. So question number 2, are there any red flags? So I guess we'll obviously have to address what a red flag is, but I will turn that over to you, Katherine.
Thanks, Wayne. So I use that as kind of just a term of art. Are there any red flags? So red flags to me are things that an employee could say in furtherance of their claim for fill in the blank: wrongful termination, discrimination, harassment, retaliation. So let me give you, for instance, sometimes I'll have somebody call, they'll tell me this person's had an attendance problem. They were late again today. We want to get rid of them. And I'll ask these questions. How long has it been going on? Oh, it's been going on for a couple months, but we kind of, it's at the last straw. Okay, fine. That sounds all pretty good. Did you meet with them? Did you counsel them? Do we have the file that we need? The answer a lot of times is no, we didn't. But the attendance is so bad. I think we're solid. We get to the end of the conversation. And it's always, oh, by the way, one more thing. She told me yesterday that she was pregnant. Okay. So now I'm going to say, well, you've got a massive red flag there, all right? Because that employee is going to say, you only fired me, not for my attendance, but because I'm pregnant. And they're going to have a good case because they're going to be able to say, if you had an issue with my attendance, where is the documentation to show that you had an issue with it prior to me telling you that I was pregnant? Okay, so that's going to be a massive red flag. And that's going to be one where I'm going to tell the employer, you're going to have a problem. I would not recommend that you terminate right now. I'd recommend you have a discussion with this individual and we get them on a corrective course of action. Even then can be problematic sometimes because you didn't do anything before. One of the biggest problems employers face is not taking action and then waiting for something to happen. I will ask questions like, has this person needed time off for any medical issues? Does this person have any mental health issues they've raised? Have they taken time off to care for a family member? Have they made complaints about ethical practices? Have they made complaints about safety issues? Have they had a workers' comp issue? All of those things are quote unquote red flags that plaintiff's attorneys very quickly argue is the real reason for the termination, not the stated reason that the company is giving.
Got it. Okay, and again, this could be opened up even to, like, in this day and age, I almost hesitate to even bring it up, but within the context of an office environment, expressing views that may not be politically aligned with the groupthink of the office, that could also be, I'm being persecuted because I support a specific political party or social justice point of view. They could also, I would imagine, that could be a part of that red flag issue as well.
It absolutely is. As we're approaching an election year, I'm gonna get a lot of calls about this. In the last election, you may recall the not the last one, the two before, when the Hillary Clinton and Donald Trump election was going on, that became a very polarized election. And people seemed to think that if you aligned with one or the other, that meant you had a certain value system, just kind of blanket. So workplaces became very heated going into that election. And we saw a lot of complaints from employees saying, my supervisor is pro this and I'm not, and he or she doesn't like me now because of it and is retaliating against me. I see a lot of it. I always tell my managers and supervisors, to protect yourself, your employees should not know what religion you are, what political affiliations you have, what outside organizations you belong to. It only hurts you for them to know that, because it will be looked at as another reason to have a difference between they and them. And that's what we don't want to see from our managers. We don't want our managers to be aligned with outside things that are going to be different than our employees.
You know, we have to invoke the principle of my now late mother, Leora Baxter, who told me when I was a youngster that we should never talk about sex, politics, or religion in public. And you basically...
Your mother was very wise.
Brilliant, beyond her, whatever. God bless her. Okay, well said. Okay, so question number 3. So we now know what a red flag is, at least in the context of the employment world. The question number 3, what is our past practice? Again, we're asking the 3 questions a business owner should ask before terminating an employee. So what is our past practice? Catherine?
I'll tell you, past practice is really important. And I'll give you an example of what I mean by that. Let's go again to this easy example of an attendance issue. I think it's just because no matter what workplace you're in, you can understand that type of issues across the board. So let's say you call me and you tell me we got this attendance issue and you've got a great file. File matches the story. You've got a new employee, maybe first 30, 90 days, they show up late. We've got a verbal warning, we've got a written warning, we've got a final warning. It's teed up beautifully. Looks like we're good. We go through the red flags. We don't see a lot of red flags. And then I say, okay, we're good to go. But what have you done in the past? Now, let's say you're calling me and you want to terminate a male employee who's 60 years old. And you say, well, I've got a young single mother who's always late. She's under the age of 40, which is the protected when you're over the age of 40 is when you get into protected age category. So now if you tell me that you've got a young female single mom who has a similar attendance issue, who has not been disciplined, who is not being fired, and you have a male who's over the age of 40, now what you can create for yourself is 2 claims of discrimination based on gender and based on age. So when you are not consistent in your past practice and your going forward practice, you inadvertently can create claims of discrimination for the company, which is why it's so important for managers to be educated on this issue, because they can inadvertently create these issues. It's also important that there is some hub for the company to understand what are the decisions that are being made, whether it's human resources or anything else. Anybody who wears 5 hats, it's okay too. But we need to know, because if you have one manager doing one thing over here and another doing one in another department, we don't look at that isolated in a box when you get sued. We look at, what did the company do? How does the company react to these problems? So we have to educate our managers, but also make sure that when we're making these decisions, we're looking at what we've done in the past. Do we have any current similar situations? And then obviously on a going forward basis.
Okay, so I'm going to bring up something that goes back to when I was in Canada. I know the laws in Canada are different than here in the United States, definitely at the state level, federal level too. But on the idea of termination based on age. So let's, in Canada, and again, this was going back now 12, 15 years, but I believe probably it's still the same. If you had 2 employees, we'll keep the gender out of it for now. Say 2 employees, 2 male employees. One was hired at age 52. The other was hired at age 38. And they both worked at that same job, did the same things for the same amount of time, and were terminated at the same time. Back when I was in Canada, that person who was age 52, will say they worked 10 years. Okay. So 52 to 62, the other person worked age 38 to 48. The person that was age 62 would be entitled to a larger severance than the person that was severed at age 48, merely because of their age. Is there anything like that here in the US?
So there is no mandatory severance in the United States. Okay, but what I will tell you is that logic does typically tend to apply when it comes to settlement agreements. So when you terminate a long-term employee who is now older, and when we're talking about the workforce, the plaintiff's attorneys will always make the argument that that person is going to have a very hard time finding a job. That person, even if they do find a job, will probably not earn the same that they did with you, because you have increased them over the last 20, 30 years, such that they're somewhat overpaid if you look at it, if you were to hire for that exact job today with a new person.
Mm-hmm.
And so it typically pushes the settlement value up a lot. Hiring long-term older employees is really, really tricky in the US. Plaintiffs' attorneys love those cases because of those arguments. Juries relate to that. They relate to the idea that here I am now, 62 years old, given my life to this company, where am I to go? Where am I going to find a new job that's equivalent, that I like, that I can do, that I have the skills for? So whenever I talk to clients about terminating long-term employees, we really like to tee it up nicely, making sure that we're giving that person a real opportunity to succeed. Sometimes the technology becomes an issue. Sometimes the skill set changes. So we want to give those people opportunity to succeed, additional training, coaching, counseling, a real opportunity to do well in that role.
So you just don't want to cut. In other words, you're not just going to cut them loose. They're going to give them a chance.
And you want to give them an opportunity to prove, to let them know what the issues might be, give them an opportunity to improve and turn it around. And in most cases, I recommend that you do offer severance in exchange for a release. It's a great way to end the relationship amicably, to make the person feel like their contributions were, awarded and respected and appreciated. And then you could do it in the context of a separation agreement where you put in a full release of claims, meaning the employee now cannot come back and sue you for any of these protected categories that we've been talking about.
Well, no surprise to me, Katherine. Once again, you've reaffirmed your expertise in the world of employment law, and I'm sure the folks that have been listening and watching today would agree with me on that. Anyone who was listening today and they felt that they should reach out, and again, reaffirming here that you really represent the employer, not the employee. Correct. But for those who are interested in contacting you, maybe they have an issue that they're concerned about, what is the best way for them to contact you?
Well, you can go directly on our website. My firm's name is Ballard Rosenberg Golper Savitt, and you'll find all my contact information there: email, cell phone, office line, whatever's the easiest way for you to communicate.
Okay, perfect. Well, again, Katherine, I want to thank you for joining us. Katherine Hren is an employment attorney and a partner, again, with Encino, California-based Ballard Rosenberg Golper Savitt, LLP. Katherine, thank you for making time for us, and can't wait to see you again. Talk to you soon.
Thank you so much for having me.
I look forward to bringing you the 3 Questions webcast, and I hope you find them educational and informative. Please consider liking this video and subscribing to our YouTube channel. And to receive a notification of when our latest webcasts are being posted, please click on the notifications bell. Lastly, to schedule an online Zoom consultation with me to discuss your wealth management needs, please click on the link in the description box below, www.onecapital.com/meet with Wayne. Thank you, and see you soon.